how are you?
Pretty good, how you doing?
Fine, thank you. I have your midterm paper with you.
Oh, good. I was hoping to get some feedback on that one.
Oh, I'm sorry?
I was hoping to get some feedback on that midterm. Hey, I don't know if you posted it on Blackboard or not. I didn't even check Blackboard.
Say that again.
I don't know if, did you post the scores on Blackboard?
I did not, I don't even know
Okay.
what that is. I
Fair
keep
enough.
getting emails about, do you want to do Blackboard, and I just ignore the hell out of it.
I would too. Blackboard is not a very user-friendly interface.
Good, well then it's all, then I'm lucky I didn't go there, because that's when I think about pulling out a pistol and shooting a computer, you know?
Yep, exactly.
So
That's-
thanks for the warning.
Yeah, that's Blackboard. Although,
But Ryan, you did very well. You had the second best grade in the class. Let me give a piece of advice. Don't go quite so fast.
did I not
You
read
skipped a
all
lot
the
of
questions?
stuff. You would have done a hell of a lot better.
Really?
And I'm gonna make that caution to everybody on the phone. Go back and read the questions again. And sometimes there'll be 3 or 4 parts to a question.
Okay.
You often answered 2 out of 3 or 3 out of 4. And I felt like you probably knew the answer to the other part, but you're in such a damn hurry to get done that,
You missed out on a free question.
Yeah, exactly.
thanks, buddy.
All right.
No, you did well. You had second best grade in the class.
Okay.
But you would have done a lot better. And I think you would have could, you know?
Yeah, yeah. How did everybody do in general?
Well. I think that very well, yeah.
Morning, how you doing?
Good, how are you?
All right.
Morning.
How'd that construction exam go for you? Dude, that one was rough.
Yeah. I saw your email, but I was running out this morning. I just running around myself and, grab what I could.
Yeah, I was sweating. I was running around Sunday. I don't know. I live up in North Palm Beach, and so there's not a lot of high-rise construction going on there. Luckily, there's like one condo tower nearby that was under construction. So running around, getting as many pictures as I could. And I was like, shit. I'm coming up short, and Monday I work in a big office building. I'm like, well, I hope I can get up to 20 in this office building. And luckily, just walking around the building, started noticing a couple more features. So I made it, but I was sweating a little.
It's after I started, I realized, oh man, there was a site here,
Oh yeah, like right here.
Yeah, so I'm saying, wow, if I just open, open your eyes, look around from the guy.
Exactly.
I mean, every day you could have just gotten one picture, but,
Right,
yeah,
for sure. Man, that exam sucked though.
yeah. Yeah, I mean, really, I mean, there were things from all over the place.
Yeah. Well, even the ones from the midterm, all the fill in the blanks, like, if I were smarter, I would have gone back to the midterm questions and made sure I totally understood a lot of those terms. Is some of those fill in the blank answers, like, I knew the concept, I just didn't remember the exact term to go in.
Exactly, exactly, yeah. Yeah, that killed me too,
Yeah, but the curve was nice, like 20 points.
Well,
He curved it. Yeah. Just this morning he sent the grades out.
Oh, wow, cool.
Yep. But he said he curved it by 20 raw points.
For real?
Yeah, it was a 50-point exam. So if you got a 30 out of 50, then you get 100%.
Wow.
Yeah. So it sounds like a lot of people didn't even even get close to it.
Close to it, yeah. Wow.
Yeah.
I didn't know.
Yeah, it was crazy.
Wow, I need to check that.
Mhm. Yeah, that was a tough one.
Yeah.
I don't want to think about it anymore. How do you think this one's gonna be?
Same, tough.
Yeah,
Yeah, yeah. A whole lot of information here.
definitely.
Yeah.
So man,
There you go. Did you get the email in time?
Yeah,
or-
yeah.
Okay. Good. Hey, what's going on, man?
Good.
Good, good. Good seeing you, Warren. Oh man, so last night I don't drink coffee at all anymore, and probably haven't for several years. I went to a Cuban place and I got a double colada. I'd never really had it before, so I'm sitting there drinking because I'm thinking it's going to be a good idea to help me study a little bit.
Yeah.
Sit out last night. I couldn't sleep last night. I was like,
Got that wired?
I was juiced. I ended up having to, had to drink a couple beers just to like put me out. Like, I literally was just sitting there in bed. Like, it was just like, my eyes were just like wide open.
That's amazing. Wow, that's strong, huh?
It's wow.
Double culotta, where you at, like Starbucks or something?
No, it's Cuban coffee.
Oh, you mean it's like a little
it's
espresso
a
type
little,
thing?
yeah, it only comes in this big of a cup, and it was a double.
It's like
And,
It doesn't sound like that much good, do you, does it? Yeah,
boy, I was wired. I was like, wow, this is worse.
good story.
Chad, you don't strike me as the type of person who needs coffee generally anyway.
I know.
Somebody else does this. I had a fraternity brother who convinced himself he needed a beer every night to get to sleep.
Yeah.
And then it became 2, and then it became
Yeah.
3. He worked his way up to 8 or 9 every night, and then it obviously had to go cold turkey for a while, but got convinced each night that
Right.
and,
Yeah. I just can't.
7's not going to work. I better have an 8. You know?
So it took 9 for the light bulb to go on.
Yeah, pretty soon it's the next morning and you're still out. Huh?
Yeah.
took his wife.
And this doesn't seem sustainable.
Well, we got a lot of stuff to cover, but I'm gonna give it a couple minutes. I know traffic is probably pretty bad and hard to travel on around out there.
Yeah, I know.
Yeah.
Alex comes all the way from Miami down in Coconut Grove. So.
Oh, wow, okay, that's no fun. That's no fun on a good day.
No.
Right.
You pass like 4 schools before you come up here.
Seriously.
Do you hear about the grades from construction? That was critical. I made the same mistake you did.
That one was horrible. So we had a construction exam for the other class, and it's a 50-point test, and the instructor sent an email saying, I was pretty disappointed with how everybody did. I've decided to curve the exam by 20 raw points on a 50-point test.
Curve?
Yeah.
So a 30 is perfect?
Yeah.
I will tell you though, like,
That's scary.
it was
Well,
It was really rare, huh?
it tells you how the test was written. If you know,
Did you guys think it was that tough when you took it?
Yeah.
I mean, you knew you were
I did.
screwed.
I was
Yeah,
like,
okay.
wow, this is.
it absolutely, and I mean, I studied for this one.
Wow.
And
I was
it
wondering
was,
material, and there's also, I felt like there were some got you
yeah.
kind of questions in there. I was like, really? That's
Even
Pretty obtuse.
Even
I haven't had to do that yet. But these are, real scores obviously on your
Yeah.
midterms, and I would expect the same thing on the final.
well, when
To
you
me,
have
there's nothing
a,
wrong with the test if it's,
that's exactly it. I mean,
if the good students can't do it,
right.
That's great.
If you present the material, people know what they're going to be graded on.
Am I technical?
Yes, sir.
Cool.
plus it's on all
Hey, we want to look at it during class.
Yeah, do it again.
Of course. That's cool, no problem. No problem at all. I just happened to think of it, honestly.
plus it's an all online course, so
Yeah.
I think even though you can ask the instructor an email question, we all kind of know that doesn't really happen as much.
Right.
And I don't know, I think you have to show some leniency when it's an online course. You can't grade it or test it like it was in person.
Did I hand you two of those? Oh, that roll sheet, are there two there?
Yes.
Okay, I'm looking for the second one, my fault.
There you
Thank
go.
Thank you. buddy.
See the email this morning from construction. Yeah.
I couldn't remember those little words.
No, same. Knew the concept, just the, I mean, what was the exact word?
No. What, you guys all started at the construction? I didn't even know.
Yeah. Right.
And this is their salary.
Glad you're back. All right, folks, we're gonna have to get started. I'm sorry for Alex is not here, but we just got a ton of material to cover. And the first thing we're gonna talk about is not on the test anyway. We've got a lot of stuff to get through, and when we get into mortgages, there's gonna be a lot of stuff on mortgages on the exam. So I hate for anybody to miss anything. So about halfway through the morning session, when somebody's got to take a break, raise your hand, let me know. We'll break for 5 minutes so that you don't end up missing something that's going to be on the test. The first thing I want to talk about for a couple of minutes is ethics. As I told you in the email I sent you. I know we know that the course title is Real Estate Law and Ethics. We don't talk a lot about it. The text talked a little bit about it, about green development and stewardship and ethics about what you build and tree hugger stuff, and that's all good, important stuff, green development. And that's a part of ethics. And the syllabus, which I don't get to change, except as to schedule, and I tried to change and was told, hands off, says that we will study ethics as a branch of philosophy applied to business ethics. And we will deal with models of ethical theories of practical use to a business person. I have no idea what either of those things means. But ethics, as I see it, and as I see it applying to a real estate deal and real estate development, is as simple as do the right thing. You've all heard this at home growing up, but what goes around comes around, and if you start hurting people in deals, they're going to want to hurt you back. We've had a couple of things that have happened in the context of some of the things we've looked at that were examples, and I'm not going to go into them because it takes too much time. But there are two reasons you want to function ethically. Number one, simply because it's the right thing to do, and you feel better about yourself and about your business. But secondly, you will get benefits back from it. Both right now, maybe in the current deal, and later for sure. You got to make people want to do business with you because you put them at ease, because they know they can trust you, and that you're not going to try to work every angle in the deal to see how you can improve your position and screw them. It can hurt you later in that deal, and it'll definitely get you a reputation. I know you've heard this before, particularly in the internet age, but your reputation is invaluable. No matter how much money you've got, hard to fix. We see that on TV right now. A real estate transaction is not supposed to be an adversarial transaction. The seller is supposed to be fired up that he's getting paid, and the buyer is supposed to be excited about what he's buying. And you're supposed to both work together to get it done, to get it closed, and not try to cut corners and hurt the other guy a little bit. It's not going to work. I want to tell you a story about a commercial real estate firm. Thank you. It was big in the 70s and 80s in Coral Gables. And just about every deal they got into, they were very successful, and they had smart people involved. Just about every deal they got into, they'd end up suing the seller for something. And every time they did a loan with a bank, and we're going to talk about loan commitments in a minute, they ended up litigating with the bank over the loan commitment. And they had lawyers who were good lawyers, but they were just as adversarial as this developer was. The developer expected them to do this. So they were nasty to all the lawyers, and they were always filing suit for something or the other. If somebody got a hangnail, they'd sue somebody. And pretty soon, banks started saying to them, we'll do the deal with you, but not if that's a law firm that's going to represent you. We want you to get somebody else. And then even continued, pretty soon, even in really good deals, they would bring to a bank. For some reason, their loan was getting turned down. People didn't want to deal with it. Litigation is time consuming, it's emotional, it's a pain in the ass, and it's a last resort. And these guys thought it was a first resort. So they kicked ass, forgive my French, and won a lot of little battles, and they lost the war. And that's all about, is the deal supposed to be adversarial or not? It's not. Good lawyers get along with each other, trust each other. Good developers love to do deals with other good developers because the people know what they're doing. And they know the other side's going to do the right thing, and vice versa. And you'll ask for an extension on something sometime. And maybe the other guy will too. And it's good to grant things like that that don't really hurt you. You'll make better deals, bigger deals, more deals in the long run. And lastly, my closing line is, make your lawyer proud to be representing you. If your lawyer ever says to you, no thanks, I don't want to do your next deal, think back about maybe why. He's not going to tell you why. He'll come up with some crap. I'm going to North Carolina or something, you know. If he really wants to represent you or do your deal, he'll get it done. But if you've given him a reason, if you've embarrassed him, or you pulled something, and it's hurt his reputation with the other lawyer, he's going to think that reputation with the other lawyer is a lot more important than your business. So, that's it. That's ethics to me. I hope that's ethics to you. And I hope you'll apply that as you go forward doing deals. And I hope you get to do a lot of deals, and you will. If you approach them in that fashion, I promise you. Okay. Chapter 21 is mortgages. This is a really long chapter. It's going to take most of our lecture time today. The materials talk about our focus in this section is financing, and without financing, they're pretty much our new deals. When we went through the recession from 2007 on, not the only people doing deals were the banks themselves and governmental bodies. But people who had to borrow, developers do borrow. It makes sense. You can't wait till you pile up $1 million to do a deal. Developers got hurt and went under because the banks weren't making loans. So it's essential that there be financing. One of the big things I want to do is equate you with the vocabulary. A lot of this stuff we're going to have to move quickly through, but it's going to be buzzwords that you're going to hear again, and I just want you to know what these terms are when they start getting kicked around in the context of a deal. Once again, we're going to have lots of stuff from this chapter on the exam. So I'm sorry you won't have the opportunity to review your notes, but that means listen up if you will. Okay. We had a chapter on involuntary liens earlier, which was, you know, somebody puts a lien on your property that you didn't want involuntarily, mechanics liens, judgment liens, tax liens. Those were involuntary liens. That chapter mentioned, although this one doesn't, this is a voluntary lien, a mortgage. You decide to put a mortgage on your property. You want to put a mortgage on your property. It can only be done by the owner signing. And we'll see why in a minute. But the point is, this is a voluntary lien. Now, a mortgage. A mortgage is simply a written instrument that uses real property to secure the payment of a debt. There has to be a debt of some type, or a mortgage is invalid. And there's lots of types of debt. We're going to talk about the primary type, where you go to the bank and borrow money and you sign a promissory note, and we'll talk about that in a minute. But there's lots of other type of debt. You know, they'll put a mortgage on your house to secure a bail bond when they bail you out of jail. Any type of debt, IOUs, for services, for anything that's a debt, you can use a mortgage on real estate owned by the debtor as security for that type of debt. Now, usually though, it's a promissory note. And we're going to talk first about what is a promissory note, and then we're going to look at one for 2 seconds, just to get the drift of what it is. When you go to a bank to borrow money for a car loan, boat loan, personal loan, line of credit, whatever, you're going to sign a promissory note. Or with a dealer to finance a car. Promissory note is a written instrument, signed by the borrower, of course, which contains the provisions of the loan, like how's it going to be repaid, and contains a promise to repay. That's why it's called a promissory note. And you're going to see in the first couple lines, it always says, so-and-so promises to pay. It's a promise, promissory note. Now, sometimes it's called a mortgage note, if there's a mortgage. But there is a note, a promissory note involved in every type of loan. And if it's secured by a mortgage, which is going to be in the context of what we're looking to talk about, it's often called a mortgage note. Okay. The note simply reflects the terms of the debt. That's all. That's what it is. It reflects the terms of the debt. It talks about how it's going to be repaid. And it contains a promise to repay. Promissory note. Let's look at the one I sent you for 2 seconds. This one happens to be in connection with a mortgage that I also sent you. But you can call it a promissory note, you can call it a mortgage note, either one. Let's look at the first page. You can see the amount of the loan, that's pretty clear. They have named the borrower here, the borrower. But the person who signs a note, any type of note, is called a maker. You don't need to learn the term maker, but they're often called a maker under the Uniform Commercial Code. Anybody who signs any kind of note is called a maker. But here in this one, they call him the borrower. But right there in the middle of the second line, the borrower promises to pay to the bank. They call him here lender or holder. Now, holder simply tells you, as is the case, often the loan could be assigned by the lender to a different lender. So we're talking about the borrower will pay whoever the holder of this note is the amount, together with interest, at the rate set forth below. Now, this tells you the payment schedule. This loan was payable interest only, monthly. Every month, just the interest. No principal reduction, just pay the monthly interest at prime rate, Citibank prime rate. This is a highly qualified buyer. He gets to borrow at prime. And that rate can change every day. So every month, bank calculates what was the rate on this day, and 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 calculates the daily interest for each of the 30 days, and sends the borrower a bill for the interest for that month, and the borrower pays it. So often there'll be a fixed payment set in here. There'll be a dollar amount. But this one has a rate that adjusts every single day. But normally you're going to see payable $3,412 a month, every month on such and such a day. But this one had a floating rate. So that big middle paragraph is all about how we calculate the rate. Next little paragraph, the entire outstanding balance together with all interest shall be due and payable by the borrower to the lender on the blank day of August 2005. You look back up at the top. Loan was dated in February of 2003, so you can see this is a 2.5-year loan. 2.5 years of interest only monthly. And at 30 months, pay it back. Short-term loan. We could go through all the paragraphs and all the terms. There are 3 or 4 important ones that we're going to study, but it wouldn't make any sense to do it now. If we have time later, we'll come back and we'll look at the examples of some of the types of clauses that we're going to talk about. Go to the end for just a second and notice, of course, it's signed by the borrower. Remember we said promissory note is signed by the borrower. And of course you already know from our discussion of entities looking at this, this is a limited partnership signed by the corporate general partner, signed by the president of the corporate general partner. So who's liable here? Well, Sam isn't personally, he's just the president. The general partner is liable for it because it's a debt of the limited partnership. And of course, the limited partnership is liable for it. And that's liable to repay the loan, which means, as you'll see in the context of some of the things we're going to talk about, not only with the property as security, responsible to pay this whole note, the whole damn thing, every penny. And we're going to see how property gets sold as the collateral to repay the loan. Well, sometimes it doesn't repay the loan. Borrower's responsible for payment of the whole note. And we'll talk about what ifs on that later, but you need to understand you're promising to pay the whole thing. You're not just putting up a piece of property and saying that's all there is. You're promising to pay every penny. Okay, that's a promissory note. Now, what does a mortgage do? In some states, the borrower actually conveys the property to the lender as collateral for the loan. In some states, there's something called a deed of trust we'll talk about in a minute, where you deed to a trustee. But in those states, that means that title to the property is actually transferred to the lender as security for the debt. You know, like a deed. Like while you're liable for the loan, you have deeded the property to the lender, you don't own it anymore until you repay it. In those states. But that's not Florida. Florida is in the other category of states, which your book talked about as the lien theory states. In Florida, a mortgage creates a lien on the real estate of the borrower, of the debtor, of the owner. A lien, you know, like our mechanic liens, or our judgment liens, or our tax liens. A lien, a claim against the title. But the bank doesn't own it, borrower still owns it, bank gets a lien. Okay.
And you said this is.
I'm sorry?
This is only second to real estate taxes as far as
Well,
property order.
if it's a first mortgage. But there are second mortgages and third mortgages and fourth mortgages. And we're going to talk about all of that priority stuff in a minute. But yeah, if it's a first mortgage, and if they do it right, Chad, if they carefully, let me go ahead and mention it. It's a first mortgage if they don't screw up something. In most cases, we're going to be talking about a first mortgage, but all those same issues are there that we've talked about before. It's a first mortgage unless there's already a claim against the property. Like, the real estate taxes, you're right, that's an exception, but like another judgment.
Like mechanics?
A tax lien, mechanics lien, exactly, that's what I'm talking about. Normally, like in this case, the lender intends it to be a first mortgage. Nobody would ever make a loan at prime rate unless he thought he was getting a first mortgage. But you can, lenders can screw up, and there are ways mechanics liens can get in front of mortgages. We'll talk about that lien priority stuff in a minute. That's all based on screw-ups we're talking about. But the real answer to your question is the recording priority of stuff that we talked about earlier. If you record your mortgage and you get yourself into first position by recording it, and then everything flows, and I'm going to map out for you in a few minutes a very complicated foreclosure scenario. But what you're going to see is this is all about who records what. And that's where these priorities come from. Who's first, who's second, who's third, who's in between, except you're right. A bank can get itself into first lien position subject only to real estate taxes. You're exactly right. It can get there. That's where it always wants to be. Always wants to be. Sometimes it knows it's making a second mortgage if it thinks there's sufficient equity in the property. But best case, and most of what we're going to be talking about is first mortgage. Okay, now, you're not responsible for knowing this, but I want to explain to you, and there's a chart in the text that explains all the differences, and you just don't need to know these. But I want to tell you what a deed of trust is. Because if you talk to people out of state, you're going to hear about a deed of trust all the time. A deed of trust, for example, is what they use in Georgia instead of a mortgage. And this flows under that concept we talked about a minute ago of title theory states. And Georgia is a title theory state. In a lot of states, Colorado, I happen to know, Georgia for sure, as the borrower, you convey your title not to the bank, but to a trustee. And that trustee holds the title to your property while you owe the money and while you make the payments. And at the end of that period, if you've repaid the loan, then the trustee, this will be a third party now, will convey the property back to you, the borrower. And if you haven't repaid the loan, then he'll either convey it to the bank or he'll sell it to a third party. Get money, give it to the bank. That's called a deed of trust because you, the owner, convey the title to a third party called a trustee who holds your title for the benefit of the bank has loaned you some money. We don't do that in Florida. And there's a chart again in your text that compares all the differences between the deed of trust and a mortgage, and you just don't need to know that. You just need to know what it is. Somebody's going to talk about a deed of trust, and you're going, oh yeah, that's putting title in a land trust. No, it's not. A deed of trust is a mortgage. And in Florida, we would call it a mortgage. And in fact, we have a statute that would deem it a mortgage. We'll talk about that statute later. That says anything that is a conveyance to secure a debt is a mortgage. Like it or not, name it whatever you want to. It's a mortgage. Okay, and therefore, and it's a lien on real estate because in Florida, by law, they're liens. So, let's talk about what a mortgage does for a minute. And let's look for 2 seconds at the mortgage I sent you the form. It's, what, 30-some pages long. This is a normal length for a bank mortgage. Lots of stuff in here. But look at the first page with me for a minute, and let's just see what's going on. This says it's a first mortgage. They certainly intend it to be a first mortgage, and if they do everything right, it will be a first mortgage. That means title insurance and title examination, etc. Now, there's a borrower here. Remember the same guy that was the borrower in the note. He's borrowing the money. There's the bank. Remember in the note, that's who loaned him the money. The amount of the loan, same amount as the note. Maximum debt, we'll talk about this in a minute. But the bank can advance more money under this debt if it wants to. And this lien, the lien created by this mortgage could go all the way up here to $3 million if the bank wanted to. And the cool thing about that is the bank can do that years later when there are already a second mortgage and a third mortgage, and the first mortgage just gets bigger and bigger. Under the terms of this same mortgage, the bank can advance more money. Okay, the land. The land is, in this one, is described on Exhibit A. So at the back there'll be an exhibit with a legal description, of course, of the land. Just like we learned, we're going to use a legal description in a deed. We're going to use that same legal description in a mortgage. And you go to the top of the next page, and this tells you what's going on here. In consideration of $10, like we saw in a deed, borrower, here, third line, borrower hereby grants, bargains, sales, assigns, transfers, conveys. All that's bull at a mortgage, because in Florida, you're not really conveying the property to the lender. But we use that same language you'd use in a deed. Makes it sound like, well, I'm really handing the property over to the lender, but you're not. But borrower mortgages to the bank. That's the operative one right here. Third line, first word, borrower, end of the line, mortgages to the bank, its successors and assigns, because the bank might assign a loan. The real estate described above is the land. Prior page, say go look at Exhibit A. So what's going on here is borrower mortgages to the bank, the land, together with, and you start going down the list here, the land, together with what? Together with number one, all the easements that go with it, all the appurtenances. You remember we talked about an easement appurtenant? Together with all the easements. Together with number two, all the improvements. That means all the buildings. Number three, tangible property. You see in the second line there, all the fixtures. Number four, very importantly, all the rents, the rental income from the property. All this stuff is getting pledged to the bank. And a couple more pages of stuff that's getting pledged to the bank. That's as far as we're going to go now. And we could go through the 30 pages of this and we could talk about every single paragraph of what's happening. And I certainly wish we had time. But we're not going to. We're just not going to have time, I fear. But once again, should we happen to have time at the end, we'll come back and do that. But that's what's going on in a mortgage. Now, the terms, the standard terms in a mortgage are the mortgagor and the mortgagee. Just like in a lease, the lessor and the lessee. Mortgagor, O-R, is the borrower. They're usually going to say that. Mortgagee is the lender, the bank. They're usually going to say that too. See if they said it in this one. I don't think they did. No. There, of course, is a move afoot to avoid all these stupid words. Grantor, grantee, lender. That's why I like to use landlord and tenant. We all know what it is. Don't have to try to figure it out. Borrower and bank. We all know what the hell that means. We don't have to sit back and think mortgagor, mortgagee, which is, okay. So that's what's going on. But the traditional terms in a mortgage are the mortgagor, the borrower, mortgagee, the lender. Okay. Now, the first step in the process of getting a mortgage is the application, of course, you know, the loan application, credit application, whatever. You go to a bank, you file an application. But what we're going to talk about is what do you hopefully get back? If the bank approves your loan, you get a commitment. That's the buzzword you're looking for. A loan commitment. A loan commitment starts out saying, we're pleased we approved your loan. But it then goes on to outline all the terms of your loan. We've approved your loan at 7%. Here's what your payments are going to be. Here's what the term's going to be. Here's what we want for collateral. Here's what's going to happen between now and closing. You're going to get me a survey, title insurance, appraisal, and it is a contract. It is a contract between the bank, the lender, and the borrower. And the bank usually signs it, but sometimes they're kind of pre-printed. But the borrower definitely signs it. Says, yeah, I agree. And it's in a commercial situation. Now, residential, I'm not sure, candidly. I don't see them, I don't want to see them. Usually the bank probably sends you a letter that says we approved your loan. But in the real context we're talking about for a commercial loan, which is hopefully the focus of this course, you get what's called a loan commitment from the bank outlining all the terms, and the borrower signs it. A bank officer will assign it, a vice president or somebody, and then there'll be a place for you to sign. And when the borrower signs it, you just made a contract with the bank. You have agreed to borrow the amount they have agreed to loan you. And in order to prove you mean it, the bank says, send me a commitment fee. You will pay, sorry?
That's the third item, is the commitment fee, or is that?
Third item of what?
Is it, you have the application, you have the.
No, well, no, that's part of the commitment.
Okay.
That's all. That's part, no.
This is all in step one,
You
application.
start the process by filing an application, but now
Okay.
we're going to talk for a while about a commitment.
Okay.
You both, bank signs a commitment, You sign a commitment, you got a contract, but the bank is gonna make you pay a commitment fee.
At that time?
I'm sorry?
At that time?
At the time you accept it, yeah. Yeah, they might charge you an application fee.
They do.
Well, yeah, so commercial banks usually don't for a good customer until they know whether they're gonna approve the loan or not. And sometimes in a residential context, as I understand it, the application fee is high enough that that serves as a commitment fee. But in a commercial context, they usually don't charge you to file an application. But if they give you a commitment and you accept the commitment, then you pay a commitment fee. Now, that commitment fee is often 1% a loan, usually 1% a loan. A lot of money. This relatively small loan I showed you as an example is $7,000. When you accept a commitment, your acceptance is not valid until you send them $7,000. It's non-refundable. Whether the loan closes or not for whatever reason. Whether you end up having bad title, bad appraisal, bad survey, can't agree on the documents, whatever reason it doesn't close, too bad, you lose your $7,000. Even if you're buying the property, even if you're part of a purchase and your deal blows up with a seller, that's too bad. You lose your commitment fee. And here's the bank's justification for that. The bank is setting aside $700,000 of their assets for the term of the commitment. The commitment will say something like your loan has to close in a certain period of time, 45, 60 days, have a time period. It'll tell you the term of the loan, 2, 3, 7 years, whatever. But it'll tell you the period of time between the time they send you the commitment and when it has to close. Usually 30 days, 45 maybe. Because they're putting a rate in there. And they don't want to get locked into that rate for 6 months either. Rates could go like this. They don't want to close that deal with you 6 months later at this rate that they agreed to when rates have gone up. So the bank is saying to you, we're setting aside $700,000 and we can no longer have it invested. It has to be liquid because you might close next week. So they're saying to you, the reason we're entitled to that $7,000 is because we had to kind of take that money out of the market and set it aside for you. And it's probably going to have, you remember we talked about liquidated damages provisions? Probably going to have one of those. Hard to calculate, the bank's going to say, it's really hard to calculate what our damages will be if you don't close, so let's all agree it's your 1% fee. That's the deal. Take it or leave it. It shows you mean it. And you need to understand, as I told you, that it's a contract between you and the bank. But here's the further part of it that makes it even more like a real estate contract. You negotiate the terms of the commitment just like you do a real estate deal. Often the bank will send you a commitment and you make changes in initial and send it back. Depends on how heavy you are. If you're a little guy and it's your first loan from Citibank, you may not want to try that. But if you're a repeat customer and you expect to have certain concessions and some reason they don't put them in this commitment, or the loan officer promised you 7 years, but they sent you a commitment for 6, change it to 7 and send it back, see what they do. They may say no, but you negotiate it just like a real estate contract, back and forth between you and the bank, until you're both happy with it. And only then are you going to pay the commitment fee. Okay, so it's a contract between you and the bank. That's the commitment. Now, we're going to shift to the general relationship between the parties in a mortgage loan. The materials call them the rights and obligations of the parties. It's really what's going on. And the first is possession. The possession, as you know, is the right to occupy the property. Now, never does the borrower transfer possession to the lender. The borrower always keeps possession of the property. Wouldn't make any sense otherwise. Even in those states where I told you where you're conveying title to the bank. The bank will in the document say, yeah, but borrower, you get to stay in possession. So realize, and I think you'd expect this, of course. You give the bank a mortgage on your house, you get to live there. Give the bank a mortgage on your project, you get to operate and develop it. But they say, maybe that you're transferring title, as you heard, and it even says you're handing over the rents and the profits and all the aspects of possession, but you're really not, no matter what it says. Until you default. Miss a payment, you'll find out very quickly you may no longer be in possession. But borrower owner keeps possession of the property. Flowing with that, of course, is rents and profits. During the term of the loan, the borrower gets to collect the rents, the profits, the benefits of the property. Again, until default. And as you saw, one of the things pledged as collateral is the rents. However, borrower normally gets to collect them until a default. And there are some situations, and there often is a separate document that I didn't send you in a commercial loan, called a conditional assignment of rents, where you separately record a document that assigns the rents. But even so, those documents say borrower gets to continue to collect the rents until default. But then quickly, long before the bank is ever able to actually finish the foreclosure of the mortgage, if there's a default, the bank is going to go after the rents. The bank is going to do something, and there are any number of remedies, and we'll talk about a few of them, where the bank can try to get its hands on your rents for the period of time it's going to take for them to finish a foreclosure action. They want that money. Because here's what's going on. You're collecting the rents and you're not making the payments. The bank wants the rents. They'll try to apply against your payments. If they get them, I mean, they don't just keep it. It'll apply to your obligations, but they don't want you pocketing the rents and stiffing them. So, borrower normally gets to collect the rents until a default, and then the bank heavily goes after the rents. Bank expects you, the borrower, to protect the security, their security, which is your property. They expect you to protect it in lots of different ways, as you can imagine. Take good care of it. Don't commit waste, stuff like that. But we're going to talk about two really important aspects. We've alluded to these before, particularly one. The bank is going to expect you to insure the property, to insure the improvements on the property. In our context in Florida, as we talked about, that may mean 3 insurance policies. That may mean a hazard policy, a windstorm policy, and a flood policy. Some places it only means 1, because those places, a hazard policy can cover all the risks. And in Florida, they keep carving them out, and then you have to go cover them separately. Now, in your insurance policy, you're going to tell your agent, or they're going to tell your agent, to name the bank as the loss payee on your insurance policy. In other words, when there's a loss at the property, you don't get the money. Money gets paid to the bank. Building burns down, insurance money goes to the bank. Bank just lost its collateral. If there's plenty of money to rebuild it, everybody's happy. There are all kinds of provisions in there about how to rebuild it. If there's way too much money, then you'll get some back. But the point is, the bank becomes the loss payee on the insurance policy. But as the owner, you've got to pay for that insurance policy. But you name the bank. Because that's one of the 2 big things that the bank is worried about that can happen to their security, which is your land and your buildings. And the second, you know this is it, real estate taxes. You are expected to pay the real estate taxes. And the reason they care so damn much about the real estate taxes is because they can be a lien prior to the mortgage. Every year when they pop up, bank has the highest priority first lien ever, except for real estate taxes. Each and every year during the term of the loan, as that year's real estate taxes attach as a lien, they attach in front of the mortgage. So the bank cares an awful lot about making sure you pay the taxes. You still pay them as the borrower. of course. But the bank is concerned about the taxes. Those are the two biggies. And because of that, because of both of these items, very often, unless you're a heavy hitter borrower, you will pay to the bank every month what are called escrows. Every month you will pay to the bank as part of your mortgage payment, monthly, assuming you got monthly payments, of course, you will pay to the bank 1/12 of your annual insurance premium on your policy or policies, and you'll pay 1/12 of your real estate taxes. And then when those bills come in, the bank will pay them. They get your money. It's a savings account at the bank to make sure that your insurance premium or premiums get paid and that your real estate taxes get paid. You will hear people talk about on loans, what's the PITI? They mean, what is the total payment? What is the principal and interest on the debt and the taxes and the insurance? Principal, interest, taxes, insurance. What's the PITI payment, everybody says? It's what's this loan going to cost me every month? What do I have to write a check for? Because that's what you got to factor into. Here's what my rental income is going to be every month, and here's my check going to the bank for PITI. Principal and interest on the loan. The loan we looked at didn't have a principal reduction until 2.5 years. You just had to pay the interest every month. But usually you're amortizing a loan and paying the balance down. So that's the principal monthly payment and the interest monthly payment, PI and TI, taxes and insurance. These are called escrows. Sometimes they're called reserves. There are reserves in loans for all kinds of other things too. But these are the two biggies we're going to focus on. Sometimes the bank will have you create a reserve for tenant improvements you'll have to do in the future, for leasing commissions you'll have to pay in the future, for major repairs. They may create a reserve for a roof repair. If you have a 30-year loan on a commercial property, they know that you're going to have a roof replacement in there. They factor in the amount of how long, what's the expected useful life remaining on your roof, how soon you're going to have to do a roof job. We'll collect from you every month, so you'll have a hunk of money built up here, have a savings account at the bank for when a new roof comes. And if any month you don't pay all of that credit, you're in default. You don't get to say, you know, I don't want to fund the savings account for the roof this month. No. Or the taxes or insurance. No, you're in default. And they lower the loan. Just as if you didn't pay your principal and interest. All becomes part of your payment. So, those are the things that the biggest obligation of you, the borrower, are protecting the bank's security. Okay, priorities. We talked a little bit about priorities between mortgages and other claims against the property. The basic rule is a recording priority, like we talked about. First mortgages, second mortgages, third mortgages, all based on, did you record first, did you record second, did you record third? You could theoretically have a dozen mortgages on your property if you could find lenders who thought you had enough equity that it was worth putting a mortgage on there and there was still some security left, you know? I mean, if your mortgages, if your total of your mortgages already exceed the value of the property, nobody's going to make another mortgage loan. You don't have any equity there. There's nothing for them to be able to recover against because there are people in front of them. But recording normally establishes the order. Two things that are weird that sometimes have nothing to do with recording because they're often not recorded. And the first one is leases, because leases often are not recorded. The general rule, and there are exceptions to this, but the general rule is that if a lease is recorded, excuse me, take that way back. If a lease is executed before the mortgage is executed, then the lease has priority over the mortgage. And if the lease is executed after the mortgage is recorded, the mortgage has priority over the lease. Now that makes sense. But remember, that's probably not based on recording, because leases normally aren't recorded. And here's what that means. The bank forecloses a mortgage, doesn't like the leases that you executed, you the owner executed after you signed up their mortgage. They have priority, they can get rid of those leases. Just the leases that were already on there when you came to them, well, they're stuck with those. Now, but normally, unless you've executed stupid leases, the bank loves it, your leases. They want the rental income. They don't want your property. They want their money. So the bank is thrilled and normally lets all leases stay and loves them and encourages them. But the bank does have priority over leases that were signed after the mortgage. Same theory makes sense too, remember? Those people that sign leases after the mortgage have the ability to go look at the public records and see that there was a mortgage recorded and see that they were coming after it. So they're subject to it. And there are all kinds of documents that we use to change those priorities, subordination agreements, all kinds of crap. But the bottom line is leases work the same way that you would expect them to. Some are in front of the mortgage, some are behind the mortgage. And mechanics liens, this is a really weird section. And we're not going to go into that. The materials talk about the priority of mechanics liens. And in Florida, it's really strange the way it works. But there are ways that mechanics liens can get in front of mortgages. There are ways, not just in a construction loan. In a construction loan made by a bank, we're going to talk about those type of loans and how they work. You know, where you really are intending to build something. I mean, where the plan, the plan is to build something. It's a construction loan to give you the proceeds to build something. There are ways mechanics liens can get in front of it. You can get in front of a mortgage. But there are also ways in general that mechanics liens can get in front of it. And all that's all about is, I told you that a mechanics lien is effective when the claimant records it. But under our law, sometimes it can relate back to the commencement of the job. And if it did, maybe it can get in front of the mortgage. We could spend 2 days talking about that. We're not going to. But understand, priorities are normally set by the recording order, with a few exceptions of ways that unrecorded things can maybe get in front of a mortgage. Unrecorded real estate tax would get in front. Maybe mechanics liens, maybe leases. Yes, sir?
Like environmental cleanup before they even start construction count as that?
Well, yeah, perhaps. Realize that if you have
And
the
it
type
might
of,
have been paid through the acquisition funding that you got through a different source. Like maybe your construction loan is just your construction loan. You know, you paid these guys to do the environmental cleanup through your acquisition loan source. And
well, if there's an environmental cleanup involved, the bank's not going to close the loan until it's done, period. Period. And paid for. We're not going to get into the environmental law aspects that can relate to transactions, but here's what I want you to know. As a part of every real estate deal, loan or purchase, virtually always the buyer or the lender makes sure that there is what's called a phase 1 environmental inspection done on the property. Just like they get a survey, just like they get an appraisal, they get what's called a phase 1 environmental inspection done by an just like a termite inspection. They get an environmental inspection done. It's called a phase 1. And the phase 1 is the environmental inspector saying that he's done a limited amount of review. The history of the property, what it's been used for. Did this thing used to be a uranium dump site 40 years ago? Aerial photographs, stuff like that. Walking around the property, but nothing piercing the soil, so to speak. No digging samples, stuff like that. That's a phase 1 inspection. If the inspector in a phase 1 inspection sees anything at all, he recommends a phase 2 inspection. That's where the environmental people go out and start taking soil samples and send them to the lab and seeing how much, it's a big, the word's escaping me for a moment, but it's everywhere. The pesticide that used to be around everywhere. Arsenic is one, and that's bad, but there's another one. in any event, it's everywhere in the ground down here. It's something we've almost had to come accept the fact that there's gonna be a certain amount. I think arsenic is the big one that they now say, it's just plain old air, period, and it's a question of levels. But it's like how much asbestos is in a piece of property. There's gonna be some. But sometimes they use linoleum tiles that had asbestos. The point is, they're kind of acceptable levels. But here's the point I'm getting at. And if the phase 2 inspector says there's then he may require cleanup. You know, that's a firm that contracts to come in and take out the dirty dirt and put in new clean dirt, or pump water out of monitoring wells until the water comes out clean, you know, and all this, or treat the wells. My point is, the bank is going to require all that be concluded. The bank is always going to get a phase 1 inspection and make sure that everything is cool. And if it indicates anything, they're going to have you get a phase 2, and if there are any problems, they're going to make you clean it up before they close the loan. And a buyer does that too before he closes with a seller. We didn't talk about that, and I regret that we didn't, because the materials candidly focus a lot more on residential than I wanted to. But that's one of the things you remember during the due diligence period that we said a buyer has a right to run all the tests that he wants. In a commercial property, a buyer always, and it's even listed in our commercial sales contract, an environmental audit is what that's called. And to see if there's any environmental contamination that has ever occurred on the property. And that's in the loan commitment, that's going to be one of the things they tell you to get. They'll tell you to get a survey, an appraisal, title insurance, and a phase 1 environmental audit, and a phase 2 if it's indicated. And then they'll make you clean it up. So it's not likely, Chad, that there's going to be an environmental lien that can precede the mortgage, because they're going to make sure there's just no environmental problem, or they're not going to make the loan. Right. Okay, now, default. Default is you didn't do something you promised to. The borrower didn't do what he said he would, or what the loan told him to do, what he promised, or what obligations were imposed upon him. Usually it's a missed payment, but not always. In the 31 pages of the mortgage, there's paragraph after paragraph of things the borrower is expected to do. Any one of them, when the borrower doesn't do something that he has promised to do or is required to do, he has defaulted. And there will be, in that commercial mortgage, I guarantee you without looking, there will be at least a full page, maybe 2 pages, defining defaults. Default is, and the first one's going to be missing any payment required by the note, or this, or that, or this after 15 days notice, or this after 30 days notice, or this, anything defined as a default. Now, here's the huge importance of the default. That triggers the most important clause in a note and the most important clause in a mortgage. That's called an acceleration clause. Every note, I can show it to you easily in this note, and every mortgage contains an acceleration clause. And here's what that says. When you commit a default, the borrower, and you miss one payment, one monthly payment, the bank gets to accelerate the balance. In other words, call the loan. You no longer just owe me this month's payment of $4,000 of interest only. We want our $731,000 right now. That's it. The whole term came forward to right now. You defaulted. There's no more 30 years or 30 months. Give me everything right now. That's an acceleration clause.
And that would be tied to maybe just certain parts of the list of promises?
At the bank's option, any clause in the mortgage. Okay. Anything. Now, of course, it's going to look at you kind of weird if it was the bank tries to foreclose a loan because you didn't mow the lawn, you know. But that would conceivably fall under the definition of you didn't take good care of the property, even though, you know, candidly, Brian, it's gonna be you missed a payment,
Yeah.
you know. But they have the right for any one of those 31 pages of requirements to declare a default, to invoke the acceleration clause, and say, give it all to me right now. Now here's why that's so important to the bank. If what you did was miss a payment, without the acceleration clause, all the bank could do would be sue you for this month's payment. Right? You missed a $4,000 payment? Great, sue me for $4,000. I'll see you in small claims court. Next month, want to sue me again for another $4,000? Okay, great. Now it's $8,000. Still see you in small claims court. But they accelerate the balance, and now you're worried about it. Now I got to come up with $700,000 quick. And usually they're angry, and they're not interested in you coming in and saying, I'm sorry, and here's a 2 months payment I missed. And not always. Sometimes they're thrilled to have it, because they don't want your property. But that's an acceleration clause. Every note contains one, every mortgage contains one. Okay, now, by common law and by statute, the borrower always has something called redemption rights. And redemption rights means, conceptually, that right up until the very end, where the borrower's about to lose his property as a result of his default, he always has the right to pay off the loan in full. The courts call that the borrower's equity of redemption, because the borrower probably has some equity in the property. So the courts protect the borrower's equity of redemption right up to the very last minute. That does not mean the right to come in and make that $4,000 monthly payment. That means the right to pay all the principal, all the interest, all the attorney's fees, all the court costs, all the default interest, all the late charges, all the everything you can have ever imagined. But he has the right to try to save the property and not lose it right up until the very last moment. And that's called equity of redemption. And in Florida, we have a statute which is a statutory right of redemption. And the materials call that the right to redeem even after a foreclosure sale, and that's true in Florida. In Florida, we have a statutory redemption period of 10 days. And I'm going to outline for you in just a minute on the board what all happens in a foreclosure procedure. But what that means is, you all have all heard about foreclosure sales. You know, we used to have auctions on the courthouse steps. I mean, weekly, but daily when the recession kicked in. We had auctions, you know, I did this, I did this. But now we have them online. But the point is, even after the auction is over, and there's been a successful bidder who wins the auction, the borrower still has 10 more days to pay the thing off. After that, whoever won the auction, the successful bidder at the auction, is going to get title of the property. Usually the bank. But some third party bid, that's who gets it. But the point is, even after the auction for 10 days in Florida, statutory right of redemption is 10 days for the borrower to pay everything before title will pass and get taken away from the borrower. Okay. Foreclosure. When there's been a default, and the borrower doesn't cure the default, or the bank does not accept the borrower's cure of default, and the bank says, no, too bad, I've accelerated, and the borrower doesn't pay, the bank is going to foreclose the mortgage. That means begin the procedure, well, the procedure. Foreclosure is the procedure by which a lender who got a lien on the property to secure the debt begins the procedure to have the property sold to pay the debt. That's what this lien is all about. You remember what we said a lien was? A lien was not a right to get the property. Any lien is a right to have the property sold to satisfy a debt. So foreclosure is the procedure by which the lender proceeds to have the pledged, the liened property sold so the proceeds can satisfy the debt, or try to satisfy the debt, or be paid down upon the debt. Now, some states have non-judicial foreclosure. What that means is no lawsuit is involved. No court proceeding is involved. You didn't make the payment, we're selling your property. Bye. That's it. Now, that happens primarily in states where we talked about the title theory. Remember, the bank already had title. Or the deed of trust. The trustee already had title. So they go ahead and sell the property. Use the proceeds to satisfy the debt. But there's no lawsuit involved. That's non-judicial foreclosure. We don't have that in Florida. But a lot of states do. And in a lot of states, this happens fast. 60 days, you're out of your house. Sheriff is out there moving your crud out, and the buyer's there with a moving van moving his in. In Florida, we have judicial foreclosure. That means a lawsuit. That means a full-blown circuit court case lawsuit filed in the county where the property is located. Okay? An actual lawsuit of borrower versus lender filed in the circuit court, and probably filed a bunch of other people too, and we'll talk about how that happens. The whole idea is to lead to a foreclosure sale to get money to satisfy the debt. I want to talk about Florida's for 2 seconds. But let me go ahead and mention a third thing that we also don't have in Florida. And that's called strict foreclosure. And we don't have that either. In those cases, and this is rare, but a couple of states have this, the bank doesn't even have to sell the property. They just, it's there, they take it. They plain old not, in other words, they're not selling the collateral to satisfy the debt. They get the property, period. Without regard to whether you had a huge amount of equity, the bank gets to keep it. That's kind of medieval, and I've forgotten, I think there are 2 states that still have that. A lot of risk there. But many, many states don't require a lawsuit. Florida does. In order for a bank to foreclose a mortgage to commence the process to sell the property to satisfy the debt. Now, I want to draw you up a factual situation and make this up on the fly. What happens in a foreclosure? But let's set up a factual thing. We're talking about this piece of property with this building on it. That's the collateral for the debt. Obviously, the borrower has pledged that property as collateral for the debt. The security, the lien. Okay, now let's say a couple things here. Let's say seller sold it to the buyer, who of course is going to be our borrower. obviously. In the year 2010, for $1 million. Okay, that's the purchase price. Let's say in the warranty deed here, well, let's say the day before the closing, but the buyer knew about this. The seller gave an easement along the side of the property here to his buddy next door. So the seller granted an easement here in favor of this property. An easement to go down a path or something along the side of the property. He did that a couple of days before the closing. This guy didn't record it, he didn't worry about that. So the buddy here, the buddy got an easement on our property. This is the property we're interested in, this one here. Buddy got an easement, but he didn't bother to record it. It came from his friend. That was cool. So, in addition, when seller sold the buyer, title's going to pass the buyer. Seller has some more property back here. In the deed here, and the warranty deed, let's say seller reserved an easement. He reserved an easement for the benefit of his property back here, all on the same piece of property, on the same strip. You know, there's kind of a roadway going through here. So before the closing, seller said his buddy could use it, gave him a written easement, but he didn't record it. But as a part of the deed, the seller in the deed reserved an easement in favor of his property back here. And of course, this was in favor of this property. But this is in the recorded warranty deed now as an easement. Okay. Part of our facts, we're going to get into mortgage now, but I want it as priorities. I want you to see these concepts about the easements. All right. Buyer, going to buy it from seller, goes to the bank, files a loan application for a mortgage. Bank loans him $500,000. All is part of the closing in 2010, right? All this stuff happens in 2010. So the bank has got a first mortgage for $500,000 on the $1 million property. Obviously, buyer put down another $500,000 of his own money. So all this stuff happens in 2010. 2011, things aren't going real well for your business, and you need some working capital. So this, by the way, let's add some more facts here. The loan officer at this bank is a real good friend of the buyer. They're buddies. So the buyer really intends to repay this loan. His buddy is there, his buddy made him the loan, and it's a straight up loan. I mean, hell, it's only 50% loan to value, but he really cares about this loan, and that's important. And of course, he signed a promissory note. I promise to repay $500,000 in certain monthly payments for whatever the term is, 5-year term, maybe. 2011, though, things aren't going real well for the buyer's business. So he goes to bank number 2. Different bank. And he borrows another $200,000. Second mortgage, bank number 2, second lien on the property. That's cool. But then things really start to tank for the business. A judgment creditor gets a judgment against Mr. Buyer. Mr. Buyer, who's Mr. Borrower on both of these loans, gets a judgment against him for $100,000. That's in 2012. But it's still cool. Still making payments on the first, still making payments on the second, but things are really going south. Somebody sued his business, got a judgment, recorded the judgment, created a lien against the property for $100,000. And then things are really getting bad. Mr. Buyer borrower here withholds for Social Security and withholding the IRS from his employees, but he doesn't pay it in. The IRS. IRS gets really pissed. IRS files a huge lien against the property for $200,000 for 941 withholding taxes, which are you withheld it from your employees and you didn't pay it to us, IRS, and they come down like the wrath of God on you, and they do. Criminal penalties too. But they get a lien against the property in 2013. And we could keep going, that things are getting worse, and we could put on mechanics liens, and we can add all kinds of stuff. Bad things happening. But hopefully you already got the drift of this. So we got a first mortgage here. Yeah, sorry I had that. We got a second mortgage. This guy probably got the third claim against the property, right? Recorded third. IRS has a fourth claim. Now,
The easement?
I'm sorry?
The easement is not recorded, so nothing happens with that.
Well, we're going to talk about that. One is and one isn't. This one is, it's in the warranty deed.
Oh,
Okay. This one isn't. We're going to talk about the effects of that. That's why I put them in there. All right, now. Things are bad now. He quits paying this one. Keeps paying this one remarkably, because it's his buddy. You don't want to embarrass his buddy, the loan officer, by defaulting on the $500,000 loan. The guy still works there. He made the loan. He'll look bad. Borrower says, no matter what, all this crud and trouble I'm in, I'm going to keep paying this loan. So this one's current. But this one, he starts missing payments. And of course, there are no payments on either of these things. They just got judgments out there. Let's talk about bank number 2 foreclosing its mortgage.
We'll accelerate the clause.
I'm sorry?
He missed a payment or two, so I'm assuming he's gonna accelerate the balance. And
I'm following. He made payments for a while. We're going to talk about what happens in 2014 when he quits making payments on the second mortgage. Did that answer your question?
yeah.
No, seriously.
I'm saying that it's gonna accelerate. They're gonna accelerate that loan balance because he's not making payments.
Exactly.
Okay.
That's what we're talking about.
All right.
He defaults on loan number 2, mortgage number 2. He did not make his $2,000 a month payments. So bank says, we accelerate, give us the whole $200,000 now. Or $180,000, whatever's left if he's been reducing the principal. Doesn't matter what the balance is. We don't care, that's not what we're talking about here. Bank number 2 decided to foreclose. Now, here's what happens in a foreclosure. Bank number 2 files a foreclosure lawsuit in the circuit court. The title of that case is Bank 2 versus borrower, buyer. Okay? That's who they sue. File suit in court. In addition, and what they say in the complaint is, hey, we made him a $200,000 loan, he didn't pay it, we made demand, we accelerated, he didn't pay that, the $185,000 is due, Your Honor, give us court costs and attorney's fees on $180,000 and okay? Now, in addition, who else might the bank want to sue? And here's the issue. Here's where this all gets interesting. Bank would like to, first thing the bank would like to do is take the property away from Mr. Buyer Borrower. That's why they sued him.
Mm-hmm.
Okay. In addition, the bank is going to sue judgment creditor. Why? Because judgment creditor's rights are junior to the bank, after the bank, and the bank would like to get their lien off the property. Okay? In addition, let's get IRS off there too. Bank doesn't want to take the title back with an IRS lien on there. Let's sue IRS. Let's sue Uncle Sam.
Who's the judgment creditor?
Who's the judgment creditor? Joe Blow. I'm sorry? This guy. The judgment creditor is this guy who had the judgment.
Oh, right, yep.
Okay.
I'm following.
This is the judgment creditor. He got a $100,000 judgment. So what we like to do here is Your Honor, we'd like to sell this piece of property. We allege that we are prior in claim to the judgment creditor. We are prior in claim to IRS, which is USA. So, Your Honor, take the property away from him, take the lien off, sell the property. But, of course, the first mortgage is still going to be on there. Bank number 2 can't eliminate the first mortgage. Now, of course, if he had quit paying the first mortgage and all this had happened, this bank would have filed. And who would they name as defendants? All the same people and bank number 2. Let's get bank number 2 off there. Bank number 1, having the first claim, would like to sell the property free and clear of everybody. So here's the point. When you file a foreclosure, you seek to take the property away from the owner, and you seek to wipe off the property all junior liens, to clear the title of the junior liens so the property can be sold to satisfy your debt, but you can't wipe off anybody who's in front of you.
Okay, so the bank number 2 is paying off the judgment creditor and IRS?
I'm sorry?
Is bank number 2 paying off judgment creditor and IRS?
No, they're wiping them out. In the foreclosure, their liens, bank number 2, is saying, Your Honor, judgment creditor's lien on my property is inferior, get it off the property. Now, they're not saying it's paid. Get the lien off this piece of property. Borrower still owes this guy $100,000. Borrower still owes IRS another $200,000. But bank just says, that's cool, we don't care. Get the lien off my piece of property so I, bank number 2, can have this piece of property sold to pay my debt. But whoever buys it at the sale